Thanks for joining this episode of the number 86 lecture series, where we discuss classical and modern jurisprudence. Today's episode features Joshua Kleinfeld, professor of law at Northwestern Pritzker School of Law. Professor Kleinfeld teaches and writes in legal and political philosophy, legislations and statutory interpretation, and criminal law and procedure. As always, the Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Who was Ronald Dworkin? Why does his scholarship matter? What does he represent, and why should we study him?
The natural law tradition split into sort of two camps, both pretty defensive in their stature. One is the continuing religious natural law tradition associated with Thomas Aquinas and in its modern form carried forward most influentially by John Finnis. The other is the secular natural law tradition. There's sort of the Aristotelian tradition, which thinks that there is something about the experience of doing law, the purpose of law in the world, that just makes it linked necessarily, inseparably, inextricably from moral considerations. I would submit that of the many distinguished thinkers in that vein, the best of them, the one with the most plausible account of at least how American law works, is Ronald Dworkin. And so I see him as the most effective and sophisticated of the secular natural law thinkers. Now, he launched his project in multiple papers and books, and there's a lot to like, and there's some to dislike. The part of Dworkin I want to single out as his best work, or his most plausible argument for secular natural law, is the Dworkin of Law's Empire. Law's Empire starts with an observation. It starts with the observation that people in the law, lawyers and judges, students and professors, people who are trying to understand what the law is, routinely disagree with each other. They disagree in good faith, or at least there's every appearance of good faith, but it's just part of our experience of doing law. There's a majority opinion and a dissent. There's a take on how a case should turn out in the classroom, and there's an argument about that take on how the case should turn out. The students and professors are arguing. There's a lawyer on both sides, and sometimes one of them just can't mount a reasonable argument, but most of the time, or much of the time, one of them can mount a reasonable argument for a different outcome for the case. So he said, what are we to make of all this disagreement? What he observed is that the whole enterprise of law is interpretive in character, that we are not just asserting this is the rule full stop, we're saying this is the rule and here's what it means in this context or in this case, and that act of relating the rule to the context or case is constantly interpretive, and he thought the interpretive activities have certain dynamics. And so what Law's Empire fundamentally is a study of how interpretive enterprises work. It covers all interpretive enterprises. It could be interpreting a poem. It could be interpreting a statute. It could be interpreting a constitution. It could be interpreting a piece of Shakespeare's theater. But he has things to say about how all interpretation works, and then how interpretation in law in particular works. And the story starts with legal disagreement. At the core of it, the heart and soul of it, is about interpretation. It ends with an attack on positivism based on the claim that if you're doing something interpretive, you just can't keep considerations of is apart from considerations of ought. That is, you can't keep considerations of or claims about what the law is totally separate from claims about what the law should be. When you're interpreting legal provisions, claims of what the law is and what it should be become entangled. That's a word from philosophy. It's not from the philosophical tradition kind of post-Dworkin. It's not one of Dworkin's terms, but it's a useful one for understanding him. Interpretive enterprises entangle considerations of ought and is. Law is an interpretive enterprise. Law entangles considerations of ought and is. And that is the Dworkinian counterpoint, the Dworkinian jab at positivism. It's a tremendous argument in two senses, because I think it's very illuminating about how American law works, maybe how all law works, and about how interpretation works. It's just a lot of facets of being a lawyer or of even being a law student, just kind of light up with clarity when you see what Dworkin's talking about. I also think this is more controversial. I also think it is a very important and telling critique of legal positivism, insofar as what legal positivism is taken to mean is that there is no necessary connection between claims of what the law is and what it ought to be. I think Dworkin has a very effective counterargument. We can query whether we think it's fully true or decisively true or how important it is, but I think it's an important counterargument.
Let's talk more about Dworkin's ideas about interpretation of rules. Are there helpful examples that he uses to explain that concept outside of the law?
So let's start with the hypothetical Republic of Courtesy. Dworkin imagines a community that is very taken with certain kinds of routines or customs of courtesy to one another. People engage in an elaborate ceremony when they see each other where they clasp hands and then they embrace and maybe they mutter some ceremonial words, and it's all part of sort of showing respect for one another and consideration of one another, a warmth toward one another. And he says, for some time, the rules, the rights of courtesy just exist as a sort of runic order. They're not questioned. There's no reason for them. We just engage in them. They're the rules of courtesy, and we engage in them whenever we see each other. But for whatever reason, we eventually develop an interpretive attitude to the norms of courtesy. And so what does that mean? It means we don't just see the rules as static. We see them as serving some point, and we can articulate the point apart from the rules of the customs of courtesy. That is to say, we shake hands because, and we can fill in the blank, because we want to show respect for each other, because we want to signify one another's dignity or our regard for one another. We embrace because we're trying to show that we're unarmed, or we're trying to show that we regard each other like family, or whatever it is. There's some sort of answer to that question because. And there's one other component of the interpretive attitude. We start to think, I'll use his language again, that the rules are sensitive to their point. You know, in test cases and marginal cases, maybe someone has no hands. Is he required to shake? Well, that isn't reasonable. And so how should that person relate to the rules of courtesy? And in those kinds of cases, we adjust the rules of courtesy in light of their point. Well, he can't shake to show respect, but he can sort of salute, and that would be adequate for the same purpose of showing respect for one another. Okay, the interesting thing now is to see that when you have the interpretive attitude, people can change the rules, even change them quite radically, while remaining faithful to the point of the rules. How does that happen? Well, imagine a pandemic. At T1, we shake hands and embrace to show respect for one another. But then there's this highly infectious disease that comes into our society, and it would not be courteous and respectful towards one another to shake hands and embrace. And so we say, for the sake of our traditions of courtesy, we have to make some adjustments. We have to actually start waving at each other from 6 feet away, or air hugging, or bumping elbows, for the same purpose of showing respect we once showed with clasping hands. So what's interesting about that is there's radical change in the way the rules are applied. But the change isn't because we've rejected the tradition that we used to be part of. It's that we've adjusted it for new conditions, or adjusted it for marginal cases.
Now, how does this apply to the law?
So when you take the interpretive attitude, considerations of what the rule is become entangled with considerations of what it's trying to accomplish, how to make the rule reasonable in application, how to make a tradition alive in practice rather than just this sort of mechanical application of rules. It is very much like the familiar distinction between the letter of the law and the spirit of the law. And one way to look at the Dworkin of law's empire is that he is the leading philosopher of the spirit of the law approach. He's giving some philosophical substance with his theory of interpretation to this notion of the spirit of the law. So now let's take it to a real case. The case is Riggs v. Palmer. In Riggs v. Palmer, there was a young man, who found out his wealthy grandfather was going to disinherit him. And he killed his grandfather before his grandfather could rewrite the will. He was prosecuted for murder, but he still demanded the inheritance. Now, the way wills work is contained within a statute, a law passed by the legislature called the Statute of Wills. In this case, which took place in New York, the New York Statute of Wills had no exception for heirs that murder their testators to get the inheritance. If you're just to follow the letter of the law, you would think, well, this stinks. This is unjust, but he's going to get the money because there's just no grounds for taking it away from him. After all, the grandfather had not revised his will. He might have been intending to, but he hadn't done it yet. He was killed before he did it. And so the grandson's going to get the inheritance. Well, the grandfather's daughters, the boy's aunts, sued, saying he should not get the inheritance. And it became a case about the letter of the law versus the spirit of the law. And the majority opinion, the majority of the New York Supreme Court at the time, said that in fact, the grandson should not inherit. Why not? Is that just disregarding the law because it sticks in the craw of justice? Or they said no. They said the Statute of Wills is an act of legislation. We're supposed to interpret legislation according to the intentions of the lawmakers. It can't possibly be within the legislature's intention that people should murder their parents and grandparents in order to get the money. Furthermore, the whole point of a will is to respect the will, that's why it's called a will, the will of the person bestowing his property after death. The grandfather surely would not have wanted his homicidal grandson to get the money over his daughters. Giving the grandson the inheritance doesn't fit the intentions behind the statute. It doesn't fit the larger intentions of just having a statute of wills, of respecting someone's will. And furthermore, it violates a background principle of justice, the principle that people shouldn't profit from their own wrongdoing. Now, there was a dissent. The dissent said we should mechanically apply the statute of wills. So here's the interesting question. Was the majority opinion, the majority of the New York Supreme Court, just being faithless, indifferent to what the law required? They were just doing what they thought was better than the law. Or were they genuinely disagreeing about what the law required? One judge thought we have to follow the letter of the law. The other judges, the majority of judges, thought we have to follow the spirit of the law. And what Dworkin argues is that isn't a case of some judges violating their judicial duty and the other judge being faithful to it. That's a real interpretive disagreement about whether to respect the spirit of the law over its letter. And what he's opening up is our ability to see that the majority might be doing something non-literal and indeed non-textual, but still faithful to the basic purpose of the law and that is an act of legal interpretation. And of course, it's an act of legal interpretation. It's obvious from that example that there are considerations of what the law is which are connected to how can the law be reasonable? How can the law be just? How can the law respect its own internal purposes? Like, how can the law respect the legislature's will? How can our interpretation respect the grandfather's will? And it just becomes impossible to say what the law is apart from saying what it ought to be, how it could be reasonable, how it could be just. Here's one way to think about it. When you say the law is X, the law is that heirs that murder their testators should get the money or should not get the money. The law is that we have a right to freedom of speech. The law is whatever. Is the law the rule? Or is the rule the hybrid of the rule and its reason? The rule and its justification? Is the law the rule expressed in the text, or the rule expressed in the text together with the reasons for that text, which affect how the text is interpreted? What I would submit is that the idea that the law is a system of rules is just a mistake. The law is a system of rules together with their justifications. When you refer to the law, think of that term law as having an equal sign to rule plus reason, rule plus justification, the hybrid of those two. And that is regardless of whether you agree with, I think that's just how American law works. It is in any case what Dworkin is trying to say about how law works in law's empire. It's the foundation of his interpretive system of law. He doesn't accept that the law is just a sort of textually given rule. The law is the textually given rule plus its justification. So I want to make a few points about this. The first is, we do this all the time in life. We say America's a democratic country. That means we should have campaign finance regulation, or we should not have campaign finance regulation. I'm a jazz musician. Jazz music is all about individuality and spontaneity and improvisation, and so it can be blended with R&B or with hip-hop and forms of fusion that carry forward the jazz tradition, says one side. The other side said, no, jazz music is all about certain kinds of instruments and harmonies and swing, and it really is not compatible with R&B and hip-hop and the like, and thus begins a whole disagreement within the jazz community about the best interpretation of jazz music. And I don't dance samba, but I bet there are disagreements in the samba community about how best to dance samba, because that's just how human life works. We have these enterprises like democracy or jazz or samba or modern science or whatever else, and we interpret them, we try to come up with the best possible interpretation of them, and we disagree with one another about what that best possible interpretation is. We do this all the time in life. We do it all the time in law as well. So Congress passes McCain-Feingold campaign finance regulation, and one side thinks this is a violation of free speech because this statute in various respects restricts people's ability to speak their mind on politics through their spending. The other side said that isn't what free speech means, and they are disagreeing about what freedom of speech and the First Amendment means, and that's part of the interpretive process of law. So Dworkin continues this with his most famous metaphor, this interpretive argument, this interpretive take on the law. Dworkin's most famous metaphor for his point of view is that judges are like the authors in a chain novel. What's a chain novel? Chain novel is where one author writes chapter 1, introduces some characters, some plot, a little bit of theme, hands it off to the next guy. And the next guy has to figure out how to carry forward the story. And that next author hands it off to someone else, and she has to figure out how to carry on the story. Everybody just gets a chapter. Well, when you're writing a chain novel, you have to figure out, you can't just start from scratch with totally new characters, abandon the old plot, then you're just not being faithful to what came before. There has to be some fit with what came before in the novel. At the same time, you want it to be a good story. And so you have to make judgments about what would make this the most compelling possible story. As Dworkin puts it, you want what you write to fit what came before and to put it in its best light. Imagine you're writing To Kill a Mockingbird, but you get it as a chain novel. So you've got the whole story. You've got Scout, the daughter of Atticus Finch. Atticus Finch is defending a black man accused of raping a white woman, falsely accused of raping a white woman. The case goes to the jury, but we don't know the jury's verdict yet. And you're thinking, what should my chapter be? Well, you could imagine the jury convicts, as that is in fact what Harper Lee wrote. Or you could imagine the jury sees that the defendant can't possibly have committed the crime of which he's accused and acquits. Well, that would be a very different book. Would it be a better book? A worse book? You could imagine some crazy event. There's a riot in the town and the courtroom is burned to the ground. Well, that might have a certain kind of symbolic quality to it, but you might also say, when did this book become sort of violent? When did this book start to become about violence in the streets? It was really about something else. That doesn't fit very well what came before it, or that isn't as compelling as a matter of theme. So Dworkin said, when a judge writes a case, they are inheriting an entire legal system, an entire tradition of interpreting, say, the First Amendment or the Equal Protection Clause or the separation of powers. And there are many, many chapters of the story that precede them, all those many cases going right back to the Constitution, interpreting these various provisions of the Constitution, or all these various cases interpreting provisions of statutes. You need to, if you're a faithful judge, you need to fit that tradition. But you also want your opinion to put the tradition in its best light. You want it to carry forward the tradition in the best possible ways. You want it to be as consistent as possible with the best notions of justice and democracy and constitutional order that are already at work in the system. So let's imagine a real case. When Brown v. Board of Education was presented, Plessy v. Ferguson was already on the books. After the Civil War, the Reconstruction Congress wrote the 14th Amendment guaranteeing all people, regardless of race, equal protection before the law. Does equal protection before the law, can it be made consistent with a segregated society, with a Jim Crow society? The Plessy v. Ferguson court had already written a case where they said, yes, it can, separate but equal is consistent with the Equal Protection Clause and with Jim Crow segregation. So the case with regard to public schools came to the U.S. Supreme Court in 1958, and they had a choice. They could apply Plessy v. Ferguson and say, this is yet another case of separate but equal, and if we're going to be faithful to our precedents, we're going to decide it the same way now that we decided it in Plessy. Or they could say, no, we're going to not fit Plessy, because what Plessy really did was gut the Equal Protection Clause, and we're going to be faithful to the Equal Protection Clause. That's what puts the overall American tradition in its best light. That's what best restores the true guarantees of equal protection. Insofar as they did that, were they reforming the law for the sake of justice? Or were they being faithful to the law that was already there? I actually think in that case, you could make either argument. You could argue that they were prioritizing sort of justice over the law, or you could argue that they were consistent with the spirit of the law over the letter of the law, or I suppose you could argue that there were just different sort of legal hallmarks. There was the Equal Protection Clause, there was Plessy, there was sort of various facts on the ground that they were responding to, and when they put them all together, they thought the best next chapter they could write in the chain novel of American law was to set aside Plessy and return to the promise of the Reconstruction Congress. But what Dworkin wants to suggest is, insofar as they do that, it's not a question of being simply faithful to the law or faithless. It's a question of trying to write the next chapter of the chain novel of American law in a way that puts the law in its best light and fits what came before it. And that involves interpretive choices that inevitably blend considerations of what the law is with what the law ought to be. I mean, you think about that. You think about Earl Warren and the Warren Court deciding Brown v. Board of Education. Were they deciding what the law is or what the law should be? I don't think that question makes any sense in that context, because deciding what the law is was inextricably linked to deciding what it ought to be. There was no way to look at the case and say what the law is no segregation, Equal Protection Clause. What the law is segregation consistent with Plessy v. Ferguson. You're trying to write the next chapter of the story, and the next chapter of the story has to fit what came before it and put it in its best light. So Dworkin called this theory, this interpretive theory of the law, he called it law's integrity. I guess he called it law's integrity because the thought is that it's supposed to have integrity in the way a building has integrity. It's supposed to be a structure that can stand as a whole, that can work as a coherent whole. I have to confess that I have always found the term law's integrity a little bit inflated and embarrassing. I would much prefer something like Dworkin's natural law interpretive, or Dworkin's interpretive theory of the law. To me, that is clearer and less kind of highfalutin in a way that's off-putting. But in any case, it's to my mind a brilliant insight about the interpretive character of the law.
This theory sounds like the opposite of what we now call textualism. Is that what Dworkin intended?
Dworkin presented his theory as an alternative to positivism. But I think today it's impossible to read it without thinking of it as an alternative to textualism. His spirit of the law approach, which is constantly looking for the purpose of a rule, the purpose of a statute, the purpose of a regulation, the purpose of a constitutional provision, and interpret the text in light of the purpose. hopefully being faithful to the text, although one could query whether judges truly are when they're proposivist, but hopefully being faithful to the text, but interpreting it in a way that's responsive to its purpose or point. It is one of the most philosophically rigorous anti-textualist approaches to legal interpretation in the pantheon of legal theory. And I think it's an argument with which textualists should contend. He makes the argument powerfully. I think much of what he says about how interpretive enterprises work cannot be denied. And so the questions that textualism asks kind of become transformed when put into dialogue with Dworkin and with Dworkin's argument in Law's Empire. You start to think, well, he's right about how, say, interpreting the Bible works. He's right about how interpreting Shakespeare's Macbeth works. He's right about the author of a chain novel maybe writing the next chapter of To Kill a Mockingbird. But that doesn't mean he's right about law, because law is different, because the way in which power is being exercised in the law requires more constrained approach to judicial power. And those are good arguments, and we should have that argument. But Dworkin is so penetrating about how interpretation works in contexts outside of law that what the textualists have to do is give a good argument for why it's different inside of law. And that's a very interesting and sort of more sophisticated level of discussion than just the old saw, which is just false. Hey, the rule's the rule, do what it says. The rule's the rule, do what it says is not the case in how American law has worked for most of its history. The rule's the rule, do what it says is not how biblical interpretation typically works. It's not how literary interpretation, it's just not how interpretation works most of the time. A lot of the time, the rule's the rule, do what it says. It works best with quantities. The president has to be 35 years old. But very often it's something like the rule itself just cannot be applied on that basis. Maybe you say police departments are liable when officers use excessive force in confrontations with suspects. What constitutes excessive force? Well, there's no way to answer that question without an inquiry into why we have a rule like that. And then you're off to the interpretive races. So let me say my last thing, less about textualism and more about positivism. Dworkin never says this in Law's Empire, but I think the whole book amounts to a simple three-step syllogism. I call it Dworkin's syllogism. And here's what it is. Law is necessarily interpretive. That's step one. Interpretive enterprises necessarily blend considerations of is and ought. That's step two. The conclusion. Law necessarily blends considerations of is and ought. Which, if any, of the steps of that syllogism are false? Is it false that law is interpretive? Is it false that law is necessarily interpretive? Could it be a runic order, as Dworkin puts it? Could it be just a system of mechanically applied rules? Maybe it's the second step that's false. Maybe Dworkin is wrong about interpretation. It isn't the case that interpretive enterprises necessarily blend is and ought. But boy, if he's right about steps 1 and 2, step 3 really does seem to follow. The legal enterprise necessarily blends is and ought. And if that's true, remember that the bone of contention between the positivists and the natural lawyers is whether considerations of what the law is are only contingently related to considerations of what the law should be. There is no necessary connection between considerations of what the law is and what it should be. Well, if Dworkin's right, what the law is an interpretive statement, which is necessarily connected to considerations of what the law ought to be. So I think if Dworkin's syllogism is right, positivism in the sense of the strong separation of is and ought cannot stand. And so I think it is a fascinating challenge to the positivist enterprise. And my own conviction is that Dworkin is right, that syllogism is right, and positivism is therefore mistaken.
Thank you for listening to this episode of the number 86 lecture series on jurisprudence. The spirit of debate of our founding fathers animates all of the number 86 content, encouraging discussion and critical reflection relative to how each subject is widely understood and taught in law schools and among law students. Subscribe to the Number 86 lecture series on your favorite podcast platform to have each episode delivered the moment it's released. You can also go to fedsoc.org/number86 for lectures and videos on federalism, separation of powers, the judiciary, and more. Thanks for listening. See you in class.